So these still at the jails, or I don't know, why didn't they do these this morning?
It's because there's a cutoff time that everyone that's booked by a certain time
Oh,
gets on the morning docket.
okay.
They get the paperwork done by then.
All right. All right, I have Mamie Davis. There's no one at the main jail. Oh, there he is. Hi. Let me see if I could get speakers on. There we go. Okay, Mamie. All right. Mamie Davis, you're charged with DUI, alcohol, um, a learner's permit violation, and 2 traffic offenses. I find probable cause. Um, the prior DUIs or no?
I don't see any.
Okay. I'm gonna set the bond on count 1 at 500. Counts 2, 3, and 4 are, there's no bond on those.
Judge, we would ask for count one to be released on a non-monetary condition, whether that's on her own recognizance or pretrial. She's 20 years old. She's lived here for the last 6 or 7 years. She lives in Lauderhill with her parents, and she's working. She makes $15 an hour for an insurance company, but she's advised that she doesn't think her parents can afford the $500 bond. So we'd ask if she could be released on her own recognizance or on supervised release.
Your Honor, I wouldn't have an objection to pretrial. I would ask that there be a condition, no alcohol or intoxicants and random testing.
No
Okay,
objection.
I'll allow that.
All right.
No alcohol, no intoxicants.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Okay, Catherine Johnson.
North Broward.
All right. Ms. Johnson, you're charged with battery, causing bodily harm, and abuse of a child without great bodily harm. Okay?
Your Honor, and I
And I do find probable cause.
thank you, Your Honor. If I could have a moment, I printed out some paperwork I'd like the court to consider, but I'm having Mr. Reedy review
Okay.
first.
All right.
I've reviewed the paperwork.
Sure. Thanks. Is this a prior arrest?
Well, for
I
the
haven't
record,
read
what
it yet, but it
what-
says 11/18.
Yeah, what I provided the court first, Your Honor, Ms. Johnson has a pending trespass involving this same victim in this victim's residence, where Judge Powell, as you mentioned about 5 weeks ago, specifically instructed her not only to not have contact, but to stay 500 feet from this address. I've also provided the court with the probable cause affidavit. In 2018, Ms. Johnson was arrested for shooting at or throwing a deadly missile against the same alleged victim. On April 8th of this year, Judge Maria Weeks placed her on 6 months probation. She just got off probation October 8th, 2019. My concern is this is ongoing and frankly escalating of violence against this same alleged victim. Now there's allegations that it doesn't just involve a victim, but her 9-year-old daughter. She has shown, based on her arrest today, that she's not willing to listen to a court's order to stay away from this woman, stay away from this residence.
Judge, I know that from what Ms. Johnson tells me, she's been a resident of South Florida for her entire life. For the last 3 years, she's been living with her mother, which is where she would go to live. She's given me her mother's phone number, and her mother, I think, is pretty much the only person who might be able to bond her out. She indicated to me that her mother babysits for a living, so she does not have a lot of money. Miss Johnson herself does not have any money. So the only way I think that really Miss Johnson is going to get released from the county jail on this charge is if the court places her on pretrial release with whatever special conditions the court believes would be appropriate. But I do not believe that Miss Johnson is going to be able to post a monetary bond.
Okay, what do you want to tell me, Ms. Johnson, anything? Nothing about your case? Okay, all right, are you asking for a bond amount, State?
Yes, Your Honor, I'm going to be requesting a $2,500 bond on count one, a $7,500 bond on count two, pretrial release with a GPS monitor, level two. I would also refer, I believe, Your Honor, if memory serves, in the probable cause affidavit for the trespass, she actually told law enforcement that she would not stay away from this residence, and based on this arrest, and if I'm wrong, I apologize, but I believe that she was quoted as saying that in that report. And based on the report, based
Okay.
on these allegations, she has clearly shown that that is the case.
Okay. All right, I am going to set your bond to 2,500 on count one, 7,500 on count two, a GPS monitor, you were to, when you pay the bond, and no contact with either victim, and you cannot go within 500 feet of the property, okay?
Okay.
All right,
How much is that?
it's 10,000.
Yes, I'll,
Is it the place of arrest, or is it?
the place of arrest, I believe, or at least the incident location.
Or
was the
incident
residence
location.
that was she was previously trespassed from. Exactly. Thank you.
Okay, Nerlene Augustin Burton.
North Carolina for medical reset.
Okay. Shanice Strauder.
Main jail, Your Honor.
All right, you're charged with robbery, firearm. I do find probable cause, State.
The state would be seeking a finding of proof evident or presumption great, and that Ms. Strauder be held no bond for first appearance purposes. I would note the allegations in the probable cause affidavit do satisfy the elements of the offense. Ms. Strauder was identified by the victim. She was also linked to the vehicle that was the subject of the robbery. Law enforcement received testimony from her mother that it was her vehicle. There's also cell phone information. As far as the court setting no bond and not exercising discretion, I would note, Your Honor, that this offense occurred in June of 2018. The state filed an information in December of 2018. Law enforcement was only able to locate her to serve the warrant on her December 25th in Dade County. I can tell you, Your Honor, as it's mentioned in the probable cause affidavit, soon after this offense, she changed her phone number. The vehicle that her mother advised was hers was ultimately found discarded. It does appear that Ms. Strauder has taken numerous efforts to conceal her identity or her connection to this offense, and there is a concern about her future appearance in court.
And we would object to the court making a finding of proof evident presumption great at this stage of the proceedings. It is the highest burden of proof that we have in our criminal justice system. The state has not produced any evidence or called any witnesses. They are relying on a probable cause affidavit written by an officer who did not witness the events in question. As far as how long it took for the police to find Ms. Straughter, we really don't have any indication from the state as to what efforts were made to find her. Did they try? Did they not try? So to say, well, it took a year or so to finally serve her or arrest her for this charge, I'd ask the court not to give that a great deal of weight because we don't know what efforts were made. So at this point, Judge, I'm going to ask the court to set a bond for Ms. Straughter to not find proof evident presumption great, or if over our objection the court does find proof evident presumption great, I would encourage the court to exercise its discretion and set bond for Ms. Straughter.
Okay, for purposes of magistrate court at this time, from what I've read in the probable cause affidavit, I do find proof evident presumption great, and there would be no bond. Okay, Christopher Arrigo.
Judge, for Mr. Arrigo, we're initially going to request a photo order for him.
Okay, I'll grant that. All right, so you're charged with resisting an officer without violence. I do find probable cause. Right now, the bond is set at $100. Okay. James Thompson.
Bond's been posted, Your Honor, I'm showing.
Okay.
Judge, Mr. Arrigo would like to try to resolve this matter today if possible. I don't have the PC in front of me, but...
And no priors.
If you haven't read the PC, should you be playing this out as his attorney?
Well,
I mean, unless
Judge,
he's doing it without you assisting him.
Judge, he
Otherwise,
is
that's-
assisting me. I'm confident that Mr. Reedy, as his counsel, reviewed that.
Oh, okay.
Yeah, I've reviewed it. If there was a probable cause argument to be made, I would have made it.
You would have what?
I would have made that argument.
Okay, so, state you have an offer?
Yes, Your Honor, upon review, and he does have a prior, but it's about 5 years ago, Your Honor. The state's offered being adjudication time served.
I'm sorry, State, could you repeat the offer, please?
Time served, adjudication time served.
Judge, he would like to accept the state's offer.
Okay, can you raise your right hand?
I think that's going to be a little tricky, Judge.
Oh, I see. Okay. Well, sir, do you swear or affirm that everything, that's not your right hand, but okay.
Sorry.
Do you swear or affirm that everything you'll tell me today will be the truth?
Yes, ma'am.
All right. Are you pleading guilty or no contest?
No contest.
No contest.
Anybody force you or make a promise to you to take this plea today?
No, ma'am.
Are you under the influence of alcohol, drugs, or medication?
No, ma'am.
All right. I'm going to find that your plea is knowing and voluntary. There is a factual basis. It's going to be an adjudication, court costs, and credit for time served.
Okay.
Okay.
Luis Alonso Rosales Ayala.
Judge, he's here. He needs the Spanish interpreter.
And we should have one on the way, Judge.
Okay.
You can have a seat, sir.
We have a second.
Do you want this back?
Mr. Gibson, come on up, sir.
Oh, there's more?
This is second document.
Oh, second, okay. What is this? Someone,
The
please.
first two
Oh, I
cases-
see.
Yeah.
All right, so Randy Gibson,
So motion to release, Judge?
Yes, ma'am.
I'm just checking to see right now if the state filed an information.
Okay.
And Your Honor, the state has not filed an information at this point. Mr. Gibson is entitled to an ROR on these charges.
All right, sir, I'm gonna release you ROR. The state hasn't filed charges, and it's been 30 days, okay?
Yes, ma'am.
It's
Yes,
not
ma'am.
it doesn't mean the case is over, it's just you're
I
being
know.
released. Okay,
I know, yes, ma'am.
all right.
All right, good luck.
Lucianne Joseph?
Yes, Judge, North Broward.
Okay. State?
And Your Honor, the state has filed an information. We're merging charges from this count into another case. So at this time, Your Honor, I would ask that the court deny the motion. When the jail receives the paperwork, they will be updating his bonds pursuant to the filing instructions.
Yeah, we were going to withdraw the motion anyway, because Mr. Joseph has other pending charges. So, if he, as I explained to him, if the motion in this case had been granted, he would no longer be receiving time served. So,
And just so, Ms. Reedy, so you and Mr. Joseph know, I believe we're merging the charges that we're filing from this case, or we have, into the other case. So he'll only have to go to court on that case. He won't have to go for two separate cases. It'll just streamline everything.
One case now, okay?
you understand that, Mr. Joseph?
They're combining it, it's gonna be one case, but they did file the charges, so we're not gonna release you today, okay?
Appreciate it.
All right, good luck, Mr. Joseph.
Dontre Anderson?
Main Joe.
Now, this is the second look, Your Honor. I was set at $1,000 on Monday by Judge Carpenter Toy, I believe.
Oh, so they
This is,
want me to lower the bond,
well,
or?
it's for your review to decide how best to proceed. I can tell you this is a filed case.
I don't even know what the charges are.
Okay, I can tell you. The charge, it's fraudulent use of a credit card. It's got $1,000 bond.
Okay.
Just checking to see if he's
Judge,
scheduled for
we're gonna,
arraignment
I'm
on-
sorry, I'm having a hard time hearing. I don't know if I'm speaking over someone.
I'll go over it again. Your Honor, Mr. Anderson was arrested last Sunday. He appeared before Judge Carpenter Toy on Monday for fraudulent use of a credit card. Bond was set at $1,000. This is a filed case. It was filed as a not in custody information. Mr. Anderson has already received an arraignment date to appear before Judge Coleman on January 6th for his arraignment.
Okay.
Judge, we're gonna ask if the court would release him to pretrial release. He said he's lived at the same address for the last 26 years with his dad and his brother. He can provide the court with that address this morning. He works actually for his dad doing landscaping, makes $350 a week, so he's unable to afford this $1,000 bond. And he informed me that he's got a newborn child that's due in 2 months. So money is
And that's
especially
not a
tight.
newborn child. It's a
Well,
future child.
d-
Just technically.
Coming up, yeah.
Okay.
So he can provide the court with that address this morning if it's in Dania.
I can have 1 moment, Your Honor. I just want to, I don't have his history. I just want to see if there is a history. I suspect the reason that Judge Carpenter Toy left the bond in place was Mr. Anderson had a grand theft in Brevard County in 2017. He was sentenced to, is he still on? Yes, he is still being supervised by the Department of Corrections for that grand theft.
So he's on probation in another county.
He's being supervised until June 26, 2021.
Okay. All right, I'm gonna leave the case the way it is. I'm not gonna lower the bond, okay? All right, Keyshawn Lee. Are you the Spanish interpreter?
Yes, I am, Your Honor.
Okay,
This is Mr. Lee right here.
we have one right after this.
This,
Okay, this is an RR also.
well, no, is this the case that was reset from yesterday, or from Tuesday?
Can you turn your sound down? It is so incredibly loud.
Right. It's an on and off. There's no volume knob, so I can turn it off.
Your Honor,
See if I could put some stuff to muffle the noise. It's really bad.
Mr. Lee had a second look on Tuesday before Judge Benson, and I believe it was reset. Trish, was it reset to see if he had a place he could stay, or? I'm sorry. Oh, for the phone. Was it the phone issue? Right. Yeah, Judge. He's being held on a possession of MDMA, possession of cocaine with intent, and possession of fentanyl with intent to sell or deliver. The bond on the first two counts was kept the same. Judge Usan over the weekend, based on, he raised the bond on the fentanyl charge to $10,000. It would appear based on safety concerns based on the nature of the substance fentanyl. There had been mention on Tuesday that if he could have access to his phone, there were family members or friends he could call about posting his bond. Judge Benson signed an order that he allowed to have access to his phone and reset the matter for today. And here we are today.
So, Judge, I understand that he was given access to his phone and able to make calls. Unfortunately, that $10,000 on count one is not realistic for him. He's asking if the court could reduce that in half to $5,000. He thinks at that point he'll be able to afford his
Okay,
bond.
there was a judge that did this already.
And Your Honor, I can advise the court, Judge Benson said on the record she was not comfortable reducing the bond that Judge Usan said. The only reason it was reset
Okay.
was to see if he had an opportunity to make calls.
I'm not reducing the bond. Thank you. The next case is Luis Alonso Rosales
He's coming up right now, Judge.
Ayala.
We're ready to proceed.
Where was the other DUI you saw?
All right, sir, you're charged with possession of cocaine.
When was the one in Palm Beach?
Señor, se le acusa de posesión de cocaína.
And 7 counts of DUI.
Y 7 cargos relacionados con una acusación de conducir bajo los efectos de bebidas alcohólicas o drogas.
One is a second offense.
This is,
Una de las acusaciones sería un segundo delito de este tipo.
One is a DUI
thank you.
with someone between the age of 15 and 18 in the
No,
car.
oh, no, Your Honor, that's either a breath alcohol above
Oh,
0.15 or
never mind.
passenger under 18.
Right. And then there's property damage for the rest.
Uno de los otros cargos tiene que ver con, pensó la señoría que tenía que ver con un pasajero de menos de 15 años, pero no, tiene que ver con una muestra de alcohol en el aliento de menos de 0.15, pero también y ser una persona de más de 18 años. Y también tiene una acusación de haber causado daños de propiedad durante un choque. Eso también es la alegación de DUI.
Okay, and I find probable cause.
La señoría decide que existe motivo fundado.
State?
Thank you, Your Honor. Your Honor, this should actually be treated as a felony DUI, a third within 5 years.
De parte del Estado, de hecho, este delito cuenta como el tercero, entonces sería delito grave de DUI.
I can advise the court, his first DUI was in 2017 in Palm Beach County.
El primer DUI lo tuvo en Palm Beach County, en el condado de Palm Beach, y fue en el 2015.
He was convicted October 23rd of 2017.
Interpreter has to make a correction. Fue la acusación del 2017 y ya fue condenado por ese DUI.
His second DUI was in Broward County.
En el segundo DUI fue en el condado de Broward.
He was convicted of DUI with an enhanced breath on August 27th of 2018.
Fue condenado de DUI y de también tener una muestra de aliento elevada. Eso es 27 de agosto del 2018.
His breath readings in that case were a .187, .188.
Las muestras de aliento en esa instancia fueron de 1.87 o .187 o .188.
Your Honor, considering this would be a third DUI,
Y entonces, señoría, ya que esto cuenta como el tercer DUI
that he had an enhanced breath,
y que también tenía la muestra de aliento elevada
and there's a crash in this matter,
y que también ha resultado en un choque en este incidente,
I believe a total bond of $15,000 would be appropriate.
me parece que una fianza de $15,000 sería correcta.
So I'm requesting an $8,000 bond on count two.
Por eso pedimos una fianza de $8,000 para el segundo cargo.
Should he post any bond the court deems appropriate,
Si él lograría pagar una fianza, la cual puede decidir la corte,
I would ask that Mr. Rosales be supervised by pretrial release.
vamos a pedir que si queda en libertad esté supervisado por el programa de supervisión previo a juicio
With a TAD monitor,
y que tenga el monitor TAG,
no alcohol or intoxicants,
que le quede prohibido beber bebidas alcohólicas o consumir intoxicantes,
random testing,
que se le hagan pruebas al azar
and no driving until further order of the court.
y que le quede prohibido conducir hasta que la corte le dé permiso.
Nothing further, Your Honor.
Nada más del Estado.
Defense?
Nothing to add from the defense.
Nada para añadir de la defensa.
All right, count one is $1,000.
El primer cargo va a ser $1,000.
And counts 2 through 8 are 2,500 each.
Los cargos 2 a 8 va a ser 2,500 cada uno.
And all those conditions that you mentioned are imposed
Todas las,
when he
con-
makes bond.
todas las condiciones mencionadas por el Estado van a quedar vigentes si logra pagar la fianza.
So no alcohol,
Así que le queda
no
prohibido
intoxicants, no driving, and pretrial release.
bebidas alcohólicas, no
Right.
puede consumir drogas y no puede conducir hasta que tenga la orden de la corte.
Okay.
¿Ok?
All right, next case is Alexis Simon.
I think he's been released to pretrial, Judge. We could check.
Okay. Jacqueline Bass.
North Broward.
Verification.
Your Honor, for the record, Interpreter Solange Sands, S-A-E-N-Z.
Thank you. Have a nice day.
Nice to see you. Have a great
You
holiday.
too.
Thank you.
Ms. Bass was released pre-trial pending her indication of address.
Okay.
We contacted someone who informed us that she lived her quote-unquote off and on, but at this time, she cannot reside at her address because she's out of town and does not trust
The only thing that I would add, Judge, I spoke with Ms. Bass before the court started. I don't know who pretrial spoke to.
The supervisor spoke to someone in Capitol.
Okay, Miss Bass has provided me with the phone number of her sister, and through that phone number, we could get the number of her niece. And from what Miss Bass tells me, she could stay with her niece.
So she will remain in verification then, and we'll get that information.
All right, and I'll give you that. I'll
Okay.
give you that information. Okay. All right, we're gonna try again to find some place for you to stay, Jacqueline. Okay.
Okay.
All right. Good luck.
I used to try Vito. Vito might let me stay there too.
Okay, I'm gonna
All
give
right.
them Vita's number.
Thank you.
Okay.
Nicole Johnson.
Paul Ryan, Your Honor.
All right. Possession of controlled substance.
It's actually possession of cocaine.
Oh,
Can I say
okay.
something?
Not right this second.
Okay.
What is this set for?
Second one.
A second load.
Yes, Your Honor.
Meaning, how much bond was given?
$1,000 bond on possession of cocaine.
Okay, so somebody guide me here.
It's just a review, Your Honor, as to
All right.
how to proceed.
Anybody want to say anything?
Yes, Judge.
What?
Miss Johnson does not have the ability to post a monetary bond. She's indicated to me that there really isn't anyone that I can call to assist her to bond out. And she does live in Orlando. She has family here locally. I think her grandmother is here locally. But I'm going to ask the court to consider pretrial release for Miss Johnson. Even though she lives out of the jurisdiction, she could still report tomorrow and report by phone. And if I'm not mistaken, could still be subject to random testing for substance abuse in Orlando at the direction of pretrial release.
Pre-trial or state? You want to guide me on this
I'm
one?
just checking, Your Honor. I'm showing Miss Johnson was arrested on a charge in May of this year that was ultimately dropped, but she was initially placed on pretrial. Even though the case was dropped, I want to make sure that from the time she was arrested till it was dropped, were there any issues with her?
She really was only on pre-trial for what appears to be under 2 months. During that time, she had to call in a friend, and she met face-to-face once. So there didn't give us a lot to
Okay.
review.
Your Honor, I can normally, frankly, I would be opposed to someone being on pretrial out of the Tri-County area. I can tell you, looking at her history, she has some priors for theft and trespass, nothing violent in nature. Considering this is a nonviolent offense, I would not have an objection to pretrial with random testing, with the understanding she would have to get her test results to pretrial in Broward County.
So she's going to reside in Orange County.
I mean, I guess, Your Honor, the only other thing I would ask for is you guys, Patrice, you guys can't verify physically, but you could call someone. You know, my concern about it. Yeah.
Right, but you can't do that because it's Orlando.
And my concern, and this is my concern with being Orange County, if she doesn't appear, then we have someone in a whole nother county that frankly we don't have
No,
any
I understand.
verification where they actually
I
reside
get it.
to serve a warrant.
Okay, I'm not gonna change the bond. I don't know if she has an arraignment set, but hopefully it's soon.
Not yet, but obviously if the defense finds anything local, they can always file a motion before a assigned
Right,
judge
I
to
mean,
have
she
it.
does have relatives here, so if they're willing to take her, then maybe the next judge will be willing to do the pretrial. Okay? All right. Good luck.
Thank you. What does that mean?
Basically, it means that, have you spoken with a lawyer while you were there in jail? Okay. We're not gonna release you pre-trial because you don't live in this county, unless you can find someone you can live with in this county. Otherwise, it's, okay, go ahead.
See, my auntie is like 80 years old, and my mom just deceased, and that's the only one that's here, that's living. And I just
Okay.
asked my mom.
Okay, well, sorry. Okay, Next case is,
That's it.
that's it? What is this? Okay, wait.
Yeah, don't